All right, good afternoon, everyone. We are going to go ahead and get started. Welcome to our webinar on the latest developments in Missouri insurance coverage and bad faith law. This CLE has been approved for 1.2 hours in Missouri, 1 hour in Kansas, and 1 hour in Arkansas. My name is Jennifer Matthew. I am the Director of ADR and Counsel for Alaris. So it's my pleasure to welcome all of you today. We just have a few housekeeping items and we will get to the subject at hand. So our next webinar we have next month is November 17th, and it's representing clients in Missouri's medical marijuana industry, something I personally know nothing about. So I'm very excited for that one. That registration is open. And then in December on the 15th, we are going to offer an ethics CLE we actually ran it last spring, and it's called the quiz, from the bar plan. And I'm going to open that registration shortly. So that is not currently open, but please look for that if you need some ethics. We all do. And then please visit our website for any future webinars. So one last thing, we're going to offer some poll questions during the CLE today. I'm trying not to be intrusive. I warned Mike about that, but we do have to do them for those of you in Kansas. So please answer the poll questions. And for those of you that are joining us by phone only, I see there's some of you. You can either email me your answers if you would like, but if you could also email CLE@alaris.us. That way we know who you are, because I don't have your phone numbers memorized. So if you could let us know that you're there, and then also answer the poll questions if you're seeking Kansas credit, that would be great. So today, after the webinar has concluded, today or tomorrow, you'll receive a survey, and we're always looking for ways to improve. So please fill out that survey. We much appreciate it, and we'll share it with Mike, even if he bombs horribly today. Which of course you won't. No, I'm kidding. But yeah, please fill out the survey. And then we also send a certificate of attendance. And so that will be your proof that you were here. And then lastly, if you have any questions today, please use the Q&A link at the bottom there. I know Mike will try to get to as many as he can. If there are questions, I know he's happy to answer them. So it's my pleasure to briefly introduce our speaker. Michael Young is a partner at the St. Louis office of Hepler Broom, with a primary emphasis in the practice of insurance law and bad faith. He represents insurers in complex insurance coverage matters at all stages of the claims process. Mr. Young also has advised insurers in drafting policy language and developing claims best practices. He is a member of the Alliance, the Insurance Coverage and Extra Contractual Committee, for the Claims and Litigation Management Alliance, and a member of the Legislative Committee for the Missouri Organization of Defense Lawyers, which I can never figure out if it's modal or model, or maybe there's another way to say it. Anyway, Mr. Young represents clients in Missouri and Illinois, and I think he's no stranger to many of you that are viewing this program today. So welcome back, Mike. Thank you very much for your presentation and agreeing to speak today, and I will turn it over to you.
Awesome. Thanks, Jennifer. I actually think you should make one of the poll questions, is Michael bombing? Make that like the second or the third one, and be sure to share the results of that.
No, but thank you.
Okay. Just a suggestion. So thank you for having me. My name is Mike Young. As Jennifer said, I'm a partner at Hepler Broom in our St. Louis office. I've been doing insurance coverage and bad faith work for about 19 years, which of course has got me the nickname Mr. Excitement. It's also caused me to lose quite a bit of hair, so here we are. So excited to join you all and talk about the latest developments in Missouri insurance and bad faith law. And as we go through this, there's really sort of three topics I'd like to talk about. The first one, settlement demands. We've had some developments on those and liability cases, attorney-client privilege with respect to coverage and bad faith counsel. And of course, what I think most people are here for is to learn about the new 537065 statute and what it means. But we're gonna cover that last, because I did want to talk about these first two topics because I think they're important. I didn't want them to be squished at the end there. So the first topic, settlement demands. 4 years ago, the legislature passed this statute right here. It's 537058. This is for liability cases, as the statute says, for personal injury, bodily injury, or wrongful death cases. And essentially on settlement demands on those kind of liability cases, the statute put forth a number of requirements that have to be in those demands. One of the key requirements obviously here is that it has to remain open for 90 days, also has to provide other information, a description of the injuries, the parties to be released, the different terms. It also requires, the amount that's being demanded has to be very specific, has to have the, HIPAA authorizations, employment authorizations, so that the insurance company can collect all these records, all this information, and try to figure out if they should settle the case or not. One of the issues that we had is, and of course, if there was a settlement demand that didn't comply with this statute, a time-limited demand that didn't comply with the statute, then the statute said that the carrier would not have had a reasonable opportunity to settle, and therefore that demand could not come into evidence in any bad faith case, which of course would, on bad faith refusal to settle cases, would make it very difficult to say the carrier was in bad faith for refusing to settle if the jury never got to hear that there was a demand that was made. One of the issues that came up and that we saw over the last 4 years was that it applied to time-limited demands, which the statute, as you can see on this slide here, was a demand that had to be accepted within a specific period of time. And so one of the things that I think the plaintiff's bar did, which was very clever in a number of instances, was they started to make settlement demands that didn't have a deadline on them. And they wouldn't say, we demand policy limits, and wouldn't put a deadline on it, or would say, well, we'll withdraw it after a reasonable time or whatever, but it wouldn't say, here's the deadline. It wouldn't say, here's 90 days, 120 days, or whatever. And the argument was, is if you made a settlement demand in a liability case and you didn't have a deadline on it, then the statute didn't apply. And therefore you didn't have to, comply with any of the requirements. And that was, a very interesting argument. And, folks had different opinions on it, but if that held up, that would have been quite a loophole in the statute. So earlier this year, this case came down out of the Eastern District. This is the Jameson versus Still case. It was a liability case where a settlement demand was made. I believe the carrier or the plaintiff's counsel left it open for 90 days. The insurance company didn't accept the demand. They countered-offered with a lower number than was demanded, which obviously is a rejection of the settlement demand when you do that. Within the 90-day period, the insurance company, though, changed its mind, and I believe tried a couple times to say, no, we will accept your settlement demand for the policy limits, here's the money. Plaintiff's counsel said, no, you've already rejected it. The carrier's argument here was pretty creative. They tried to say, well, under the statute, we get 90 days to accept it, no matter what, and so if we rejected it on day 24, so what? We still have, an additional, whatever the math is, up to 90 days in order to sell the case. And the Eastern District rejected that argument and said, no, when you offered something other than what was demanded, that was a counter offer, you rejected the demand, that's it. So that was a fairly uncontroversial decision. However, they did have this key language where they explained why that is, why they ruled that way. And what they said here, and you can see it on the slide, is that with this statute, the legislature weighed in on the key element by setting out by no fewer than 8 requirements with which a demand for settlement must comply in order to be a reasonable opportunity to settle. One of those requirements is that the demand remain open for 90 days. And if the demand fails to comply with any of those requirements, the demand shall not be admissible. They conclude that the statute provides certain clarity with respect to what shall be considered a reasonable opportunity to settle in a later bad faith refusal to settle case, but they say requiring by codifying the requirement of the demand. So I think that, it's fairly, this is what the opinion says. On its face, it's sort of rejecting this argument that you could get around the settlement demand statute by not putting a deadline on your settlement demand. And it's, on its face, it's saying, no, if you're going to make a settlement demand for bodily injury, wrongful death, or personal injury, you have to comply with 537058, which means you have to leave it open for 90 days and have to do all these other things. So very interesting decision. It comes, almost 4 years after the statute was passed. I know a lot of carriers paid a lot of claims thinking that there was a loophole in the statute. Jameson kind of suggests that there's not. So pretty significant development with respect to settlement demands. The next topic on our three here. The second one is attorney-client privilege. And, very challenging area when there is a case with bad faith issues or coverage issues. Oftentimes in liability cases, the insurance company is going to hire obviously defense counsel for the insured, often under reservation rights, but they're also going to hire their own coverage counsel, somebody like me, and call them coverage counsel, bad faith counsel, whatever you want to call them. And, the question is, what is my role in those types of cases? And is my file privileged in any litigation? And we had a case a few years ago, the Shelter versus Wagner case, that came down pretty strong and said that coverage counsel's file and opinions and correspondence with the insurance company is all privileged, that insurance companies are entitled to hire their own counsel to provide them with advice. So we had a very interesting case that just came down at the end of August. It's this Kilroy versus Moriarty case. Folks here in the St. Louis area probably remember, a few years ago, the Kilroy Bar, which is next to the ballpark in downtown St. Louis, a sudden storm came up. They had a tent set up, and I think, someone was killed. There were other injuries. And so some pretty significant litigation came out of that. One of the insurance companies hired, hired defense counsel, which you see there is referred to as McBreedy. And then they also hired their own coverage or bad faith counsel, Mr. Phoenix. And what happened here, according to the court, is that the coverage counsel or bad faith counsel that was hired by the insurance company, in the appellate court's view here, went sort of beyond the role that they envisioned that coverage counsel should take. Okay, and what sort of things are we talking about? Well, you can see here on the slide, it says that, coverage counsel appeared to have embedded himself as defense counsel's co-counsel in Kilroy's defense in the underlying lawsuit. And here's this nice little summary of what they said that the insurance company's coverage counsel did. They said that he extended settlement offers, attended motion hearings, provided legal research and local rule information to lead defense counsel, participated in witness preparation, reviewed motions prior to filing, negotiated settlement with opposing counsel, and reviewed jury instructions. So the appellate court concluded that even though counsel was hired in order to provide advice and recommendations to the insurance company only, they felt that his activities on this file went beyond that, right? And they ultimately concluded that, they said that he was, counsel was participating in this, the court called it de facto co-counsel of Kilroy, the insured, even though his undivided loyalty ethically belonged to Starr, the insurance company. And they went on to say that the problem with that is that if someone is acting as counsel for an insured, under Missouri law, that insured is entitled to that defense counsel's file, at least insofar as that person is undertaking things in order to defend the insured. And so, the motion judge originally quashed a subpoena from the parties asking for information from coverage counsel's file. Appellate court on a writ reversed that decision or set it aside and said, no, we're going to send it back to the trial court. And we think some of the information that was in coverage counsel's file actually needs to be turned over to the plaintiffs in this case, because he was acting, even though he was retained as counsel for the carrier, he was doing things essentially on behalf of the insured, and that allowed the insured to get some of these file materials. And I know there's been all kinds of discussion about this case and how far does it go. And it's I think yet to be seen to a certain extent, but I think, and you can, I'm just flipping back here and looking at the different things that the appellate court said that coverage counsel was doing, a couple of them, don't seem to be beyond the role of what coverage counsel might undertake. For example, they said that, coverage counsel extended settlement offers. Well, when you're in these cases, where there's coverage issues, or maybe there's a settlement demand as there was here, and the carrier didn't want to pay it, and the insured wanted the carrier to pay it, defense counsel hired to defend the insured is in really a tough spot, I think. And defense counsel may not be able to extend settlement offers. And so who does it? Can't the insurance company hire its own counsel to do that? I sort of think that they should be able to. It's not clear if that practice is now frowned upon, but that's certainly something. Attended motion hearings, again, I don't think simply having coverage counsel attend a motion hearing or trial, for example, is necessarily a bad thing. Sometimes you want to see what is happening. You want to see what the evidence and arguments is, and insofar as it affects the coverage issues. But I think the next couple things here is really what, kind of troubled the court, providing legal research to be provided to the actual defense counsel, reviewing defense counsel's motions prior to filing, reviewing jury instructions, providing all that kind of information. That's the sort of thing that I look at that and I'm like, that probably is going beyond coverage counsel's role in these sorts of things. So I don't know if simply making settlement offers or showing up in the courthouse, which is a public place, at least once COVID is lifted, is necessarily fatal for the insurance company's counsel, but doing some of these other things, probably is. And so it's a good lesson for people like me to be very careful about what we're doing here in order to preserve counsel. And I see there's a question here. Had the lawyer routed all of his comments through the claims handler and not working directly with the insurance defense counsel, would the materials remain privileged? According to the court, I don't think so. Because some of these stuff, like for example, the legal research, if you go through the opinion, that was actually, I think, according to the opinion, provided from coverage counsel to an adjuster who then routed it to defense counsel. And the court, I think, found that problematic. Now, certainly there were other things where coverage counsel and defense counsel were communicating with one another directly. I don't think there's anything inherently wrong in that. The problem here, though, was, according to the court, is that coverage counsel was doing more than just communicating with defense counsel. He was kind of like teaming up with him, as you can see, as it's characterized here as co-counsel for the insured. And that's where it gets problematic. Now, I will say, as my partner, Katie Jacoby, who works with me out of our Chicago office, will say that the appellate court could have gone much further here and said that coverage counsel's entire file is now subject to review by the insured and the plaintiffs in the case. And the court didn't do that. Court just said, look, some of these materials here, if coverage counsel is doing things for the insured to defend the insured, those are the materials that may have to be turned over, not necessarily everything. So I don't know. I mean, it's an important case. We all need to think about what it means and how it affects our practice, but I don't know if it's as catastrophic as some people on the defense side and the coverage side initially have said.
Mike, we have another question. I'm sorry to jump in.
Yeah, absolutely.
And I'm going to launch the first poll too, but here's the question. Isn't coverage consulting counsel best suited to negotiate above the insured's policy limit? That's not a benefit even within the insured's policy, extra contractual.
Yeah, I think it's a great question. And it gets to the point that I mentioned earlier is, when you're in this conflict situation, defense counsel they're really in a tough spot to be undertaking those negotiations because the insured may not want that. And so if the result here is that no, coverage counsel can't do that, what that effectively means is that the insurance company can't hire counsel ever to negotiate, that the adjuster or the in-house person always has to undertake those settlement negotiations. And, who knows, maybe that's what the appellate court's getting at here. I kind of doubt it, though. I think it's really these other things, providing legal research, reviewing motions before they're filed, prepping witnesses. I think that's the more problematic stuff. And that the court is just talking about the settlement offer piece to kind of, give a fuller picture of what the court felt was going on here. But no, it's if the rule is, outside counsel for the carrier can never engage in settlement negotiations, that would be I think, a harsh rule, and would honestly, in a lot of cases that we work on, would hinder settlement, because sometimes, it's just easier for lawyer to lawyer to talk about this stuff than it is for the claims person who may not have a relationship with the plaintiff's counsel or the insurance counsel. So I think that's a good question. I don't know if anyone has anything else on that one. So that's the Kilroy versus Moriarty case, dealing with privilege. Okay, so those are the first two topics I wanted to talk about so they weren't get lost as we now move into 537065. I like to joke that the people, lawyers, and everyone that practice in this area handle these kind of cases in Missouri that they know two numbers. Okay, the first one is 8675309 from that Jenny song. The second is 537065. Hard to tell that joke when people aren't allowed to talk, and maybe it wasn't funny, I don't know. But in any event, 537065 is a significant statute when it comes to insurance coverage and bad faith cases. And it's, in these liability cases, it's what we face, plaintiff, defendant, whatever. All these cases, in some fashion or another, touch upon 537065. So, okay. That statute was amended this year and became effective August 28, 2021. And so what are the changes? What's going to be different compared to where it was before? If you look at the new statute, it's in some ways it's kind of bizarre to see all the, the way that it's set up now. And I don't think it makes any sense unless you kind of know what came before. Okay, what was Missouri law under the first 065, the one that was changed in 2017, and the cases and the rulings that came from those are all the, I think you have to understand what happened before to make any sense out of what we have now. Okay, so just to kind of walk through that then a little bit. And I know for some of the folks on the call here, this may be elementary, some of it may not, but I think it helps a little bit to go through it. So when you have a liability case in Missouri and the insurance company's looking at it, maybe there's some coverage issues, maybe there's an intended expected exclusion that might apply. If it's a homeowner's policy, maybe you have a business activities exclusion that could apply. Maybe it's not exactly clear. What does the insurance company do? In Missouri, you have three options. The carrier does. The first one is that the carrier could defend the case without a reservation of rights, okay, subject to the policy limits. If the insurance company does that, they just lost their coverage defenses, okay? Now, the upside for the carrier then is they can control the defense of the case, clearly get to pick their own defense counsel, but they bought that lawsuit subject to the policy limits. The second option that they have is they could decline coverage. We're not going to defend the insured. We're not going to indemnify the insured. And that has a lot of consequences, obviously, in Missouri. The third thing the carrier could do is defend under reservation of rights. And this is a situation where the carrier communicates to its insured and says, look, we're going to give you a defense. We're going to pay for defense counsel, but we're going to reserve our rights to assert our coverage defenses later, okay? So if there's a judgment entered against you, we may not pay it. If there's a settlement, we may not pay it, or we may pull the defense altogether later, depending on what happens in the case. We're reserving our rights to not pay or do anything because we have these coverage defenses. Missouri's a little unique, I think, amongst the states in that the insured here has the right to reject a reservation of rights. And it's a very significant right that the policyholder has, because once that reservation of rights is rejected, now the ball is back into the insurance company's court. And they have to decide, what are we going to do about this? And here are the three options. The insurance company can withdraw the reservation If they do that, that's essentially a defense without reservation. They've given up the coverage defenses. They get to control the defense of the case, but they've just bought that case, subject to the policy limits. That's one option. They can refuse to withdraw the reservation of rights. That's the second. Or they can file a declaratory judgment action. If the insurance company does the second or the third in this situation, that is, after the reservation rights has been rejected, if they do number 2 or number 3, that is deemed a denial of coverage in Missouri. And as we'll see, that has a lot of consequences. So how does this fit into 065? Here's the original 065 statute. This was passed in 1959 during the Eisenhower administration. On its face, it's pretty simple. It's essentially just a covenant not to collect statute against the insured. It simply says if there's a case for bodily injury or death, if the plaintiff gets a judgment against the tortfeasor, that they will agree to collect just against the insurance company, that they will not try to collect against the insured. Over time, what we saw, though, is that agreements under the statute, in my view, other folks will disagree, sort of went beyond the statute and would essentially, you would see situations where the agreements would say that the insured would fire the defense counsel put on by the insurance company, that they would agree to certain facts or stipulate to liability, that they would agree not to put on a defense in the case. They would, agree to have the case transferred from one county to another, usually either St. Louis City or Jackson County, Missouri. And what would happen then is that once the cases were in certain jurisdictions, there would be a hearing held, there would be some evidence put on, various levels of evidence, sometimes a lot, sometimes not so much. And then you would have the court entering judgment against the insured. Typically, these numbers were fairly large. The judgments would also typically have findings of fact that tried to show that, the case was actually covered by the insurance policy. Over time, we also saw another development where the determination of liability damages and findings of fact weren't even necessarily undertaken in court, but plaintiffs and insureds started putting provisions in these agreements where they would agree to a private arbitration, right? And an arbitrator would look at the materials and, again, various levels of evidence and, formality would be put on, and you would have arbitration awards entered, typically large numbers, findings of liability, and in fact showing that cases are covered. Obviously, arbitration awards on their face are not enforceable. Plaintiffs then would have to file a lawsuit to get a judgment entered in accordance with the arbitration award, and that was often done. So, this and the courts largely approved this sort of litigation practice between plaintiffs and insured. So when the statute was used, it was a very powerful weapon that plaintiffs and insureds had against liability carriers, to try to show claims were covered, get large awards. And this obviously has resulted in a ton of litigation, a lot of settlements that insurance companies might not otherwise make. And it's really been, if you do bodily injury work in Missouri liability cases, this is the statute that often people push whenever there are coverage issues involved. So that was the practice under the original statute. The question always was, under the old statute, which existed up until the summer of 2017, is, well, when could you do one of these deals? And what the case law said is that there were 2, maybe 3 ways a plaintiff and insured could do one of these agreements. The first one is if the insurance company declined coverage, right? So like I said earlier, if the insurance company denied the case, or if they reserved rights and that was rejected and they didn't withdraw the reservation, that was a denial too. If you had a denial, there was no question you could do an 065 agreement. The second way, under the cases that they said back then, this is pre-August 28 of 17, is that if the insurance company refused to settle within policy limits in bad faith, Okay. Not every rejection of a settlement demand within policy limits would allow folks to do an 065 agreement. It had to be in bad faith. However, no one knows they're in bad faith until a court tells you you're in bad faith. So the practice was, as many times the settlement demand was made, if it wasn't accepted, plaintiffs and insureds would do 065 agreements. And no one really knew that if they were valid or not until the issue was ultimately litigated. And that seldom happened, before a settlement. The third way that some people argued that you could do an 065 under the old statute is simply if the insurance company defended under reservation rights. And there was a case from the Supreme Court that a lot of people argued said that. I don't think it did. I think number one and number two there were the only ways you could do an 065 agreement. But again, there was uncertainty under the old statute. So in 2017, Eric Greitens is elected governor and the 065 statute is amended. And here's a couple of things that it did. First of all, it added personal injuries to the category of claims that were now subject to the statute. It used to just be bodily injury or death. Now it included personal injury. Fortunately, the statute did not define personal injury. Many of us sort of thought it meant the personal injury kind of coverage that you would see, for example, under coverage B, under a CGL policy, or personal injury that you sometimes see in homeowners policies. So we're talking about, invasion of privacy claims, slander claims, malicious prosecution, false arrest, false imprisonment, these sort of, quasi-intentional tort claims that could be covered under personal injury coverage. The statute also tried to clarify when you could do an 065, because remember, when the original 1959 version, no one was exactly sure if simply reserving rights let someone do an 065 agreement. Legislature added this language to the statute and said that you could do one of these deals if the insurance company had the opportunity to defend the tortfeasor without reservation, but refuses to do so. The intent, I think, of the folks that wrote that meant it to be you could do one of these deals if there was a denial or if there was a reservation of rights that was rejected and the insurance company refused to withdraw it. Now, we can all debate whether or not that language that we see in bold on the screen accomplished that, but that was the intent. You still had this issue then where many people felt like simply reserving rights let folks do 065 agreements. So even though they tried to clean up that issue, it was debatable whether or not that was very effective. So those are two changes to the statute that were made in 2017, but here's the big one, okay? They added this sentence to the 065 statute. This did not exist before 2017. It says, before a judgment could be entered against a tortfeasor, the insurance company had to be provided written notice that an 065 agreement had been entered, and the insurance company shall have 30 days after the receipt of that notice to intervene as a matter of right in any pending lawsuit involving the claim for damages. So Missouri in 2017, we became an intervention state. And it's as goofy as it sounds, there's actually a number of states that allow liability carriers to intervene into liability cases to prevent, what the industry might refer to as a setup judgment or a consent judgment, participate in liability and damages. The thinking here is that, we were going to make liability cases a little bit like UIM cases, an underinsured motorist or even an uninsured motorist cases. If the plaintiff sues the underinsured motorist and the UIM carrier knows about it, the UIM carrier has a right to intervene into that case and litigate liability and damages. They sort of took that concept and slapped it onto liability cases. And so that's what we became. But the key language here is that we had to be given notice of the execution of the contract. Doesn't necessarily say when, but we have to get notice. And then 30 days after the receipt of that notice, we could intervene, the insurance company could intervene in any pending lawsuit. that pending language turned out to be pretty significant. And we'll get to that in just a minute. As far as the timing of it goes, the Supreme Court, there was a debate, whether or not the 17 amendments were going to be, retroactive or just prospective. And what the Supreme Court said is that this statute applied to all agreements entered on or after August 28 of 17. Any agreement entered before that would be subject to the old statute, and the right to intervene would not be there. I bring this up because the new statute that was just passed, the 2021 version, has the exact same language which was interpreted under the old statute. So that thinking is probably going to carry forth, is that the key timing of the 2021 statute will probably be when was the agreement entered, where it was the agreement entered before or after August 28 of 2021, but we'll get to that in a minute. So that was the effective date. Under this statute, the 2017 version of it, as I mentioned earlier, the language was not necessarily the clearest on when you could do one of these agreements. That issue was, in my mind, largely settled by this Stacy versus Bar Plan case from 2021. This was a case where the insured and the insurance company got into a fight over the limits and how many limits were available. And, the insurance company sent correspondence saying, here's what the limit is. You only get one, not two or three or four. The insured said that was a reservation of rights letter and rejected the reservation. The insurance company refused to back away from their limit position. So then they did want an 065 agreement, got a judgment entered. And the question is whether or not that agreement was enforceable or not. And the Eastern District said no. They first said that the insurance company asserting a limit of liability is not a reservation of rights. Okay, that was always a debate that we heard, during in these cases. But they said, look, asserting a limit, that's not a reservation. Okay, and since it wasn't a reservation, the insurance company didn't decline coverage. Since they didn't decline, the plaintiff and the insured could not do an 065, and therefore the judgment that was entered was not bounding on the insurance company. But the key thing here is this case, I read it anyway, to suggest you really need a denial of coverage in order to do an 065 under this 17 version of the statute. Okay, and by denial, I mean either an actual denial or a reservation of rights that was rejected and the insurance company refused to withdraw it. That's how I read Stacy versus Bar Plan. But it's not perfect. Okay, there was still some unclarity on that piece of it. The big thing though under 065, and if the plaintiffs and the insureds were smart about these cases, they could largely defeat the insurance company's right to intervene in these cases under the 17 version. And the reason is this language that we had back here is that you have the right to intervene in any pending lawsuit within 30 days of notice. And so we had 4 cases come out, and I won't go through all these in detail, but you have the citations there. The takeaway is that if the insurance company got notice of the agreement, if there was no pending lawsuit within that 30-day window, they lost their right to intervene. So like, for example, in the Britt versus Auto case, there was no lawsuit. They did an 065 agreement, gave notice of it to the carrier, wait 30 days, then they filed suit. Carrier tried to intervene, and the appellate court said, no, you can't intervene. You didn't intervene within 30 days of the lawsuit. Insurance company said, wait a second, there was no lawsuit to intervene within 30 days. Appellate court said, we don't care. If there's no lawsuit within 30 days, that's your problem. That's what the legislature wrote. Aguilar was a similar deal. There was a lawsuit. They gave notice of the 065. The case was dismissed without prejudice. They waited 30 days, refiled. Geico tried to intervene into the case. The appellate court said, no, you didn't intervene within 30 days of the pending lawsuit. They said, well, they dismissed. Again, it doesn't matter. The Knight case there, this is one where there was a lawsuit. The plaintiff and the insured did an 065 agreement. but didn't tell the insurance company about it right away. And then they went and did a private arbitration, got an award entered. Then they gave notice to the carrier of the 065 agreement. The carrier intervenes into the case and tries to argue that that arbitration award should be set aside. And the Western District said, no, you have the right to intervene. You did that right. You got into the case within 30 days of notice of the agreement, and you're in a pending lawsuit, but you have to intervene. And when you intervene, you have to take the case as it is, and when you intervened, that arbitration award was already entered. We're not going to let you set it aside in this case. And so, and Loveland had some similar facts where a court actually did set aside an arbitration award because the carrier intervened. Plaintiff dismissed that suit, refiled. The insurance company got into the case. They took a change of judge, new judge, and they said, please let us set it aside like the court did before. They said, no, I'm a different judge. I don't agree with that, and I'm not going to set it aside. So, you can read all these cases. They're truly the procedural Olympics, but the bottom line is that if the case could be, positioned, I will say, so that there's no pending lawsuit within 30 days of one of these notice of 065 agreements, the carrier is just kind of out of luck and can't do much about it. And so it effectively defeated the carrier's right to intervene that the legislature had intended, according to the language of the statute. So we now have, and I will say this too, the insurance company, I think it was State Farm in the Knight case, also challenged the arbitration process and said this was collusive and fraudulent. The appellate court said no, that what went on in that particular arbitration is really not too much different than what happened in trial courts, where they would have these mini hearings and enter judgments under the statute. And so therefore, we're not going to say that this arbitration process in general is somehow so collusive and that it's akin to fraud and void. So this Knight case sort of condoned the arbitration process that was going, is an in run around the carrier's right to intervene. Another issue that came up during the 2017 version of 065 is, well, what happens if we do intervene? If the insurance company does intervene and can litigate liability and damages, do we get to do anything? And there was some language here. This first one is from the majority opinion, and then there's a comment here from a concurrence where there was some questions raised does the carrier even get to litigate liability or damages even if they do intervene? And the issue is that the 17 version of 065 said the liability carrier gets to intervene into the case. It doesn't say what they get to do. And so that was a potential issue, right? And you see the Supreme Court here in these sentences kind of kicking this idea around. I will say this issue just came up over the summer, and the Western District, if you read the decision, suggested no. If the insurance company is in the case properly within 30 days, there's no arbitration award, they do get to litigate liability and damages and engage in discovery. And this was a case where the amount of damages was an issue. The trial court said that the insurance company did not have the right to depose the plaintiff. And the Western District said no, that was error, that they should have been allowed to depose the plaintiff. Now, the court also said there was no prejudice from that, which we on the defense side can debate. But the issue here is, this case sort of suggests once you intervene, you do get to do some things. But again, this is the appellate court. The other case was from the Supreme Court. So how will that play out? That was the 17 statute. So what happened in, let's see if there's a question here. Yeah, there's a question here about, some of these arbitrations have been rather large judgments. What's the best course for the insurer to take in order to prevent these? And I would say, why don't we chat about that outside the course of this webinar here? Happy to chat with you on the phone or email about that, and I can give you all kinds of thoughts on what insurance companies can try to do under the old version of the statute to try to prevent these judgments being entered. So sorry to dodge on that, but we'll touch base on that later. The new statute here that was just passed in 2021 did all kinds of things really in a reaction to everything I just talked about for the last 20 minutes. Okay, trying to close up loopholes, fix things in the legislature's mind that they didn't like see happening with the courts. The first thing that they did actually isn't even in the 065. They added some language to Missouri's version of the Uniform Arbitration Act and basically said, as you can see the language here in bold, that any arbitration award for personal injury that was subject to an arbitration that the carrier did not consent to is now no longer binding on any insurance company. So they just tried the private arbitration route, under this new version of these reforms is kind of dead. Okay, at least unless it's challenged on some other grounds, I guess. But on its face, those arbitrations are now no longer valid in Missouri. So you have to go to court in order to get your judgment and litigate the liability and damages issues there. That's the first thing it did. The second thing that the 2021 revisions did is it finally, in my view, clearly said when plaintiffs and insureds can do 065 agreements. And you can see they struck the old language, that old opportunity to defend without reservation, got rid of that, scratched it out. And they said, here's when you can do one now, plaintiffs and insureds. If the insurance company has refused to withdraw a reservation of rights, that is, they reserve, it's rejected, and they won't pull it, you can do an 065, or if the insurance company declined coverage for the case. So you have to have a denial or a refusal to pull an ROR in order to do an 065. Simply doing a reservation of rights under the 2021 version of the statute, it says you're not supposed to be able to do an 065. Again, this applies to personal injury, bodily injury, or death cases. So in 17, Missouri became an intervention state, and we had 30 days to intervene in any pending lawsuit. So we went through 3 or 4 cases where the parties were able to get around that. You would think that the legislature would do away with this intervention stuff, right? No. Missouri legislature doubled down on the intervention process, and this is in the new 065. An insurer who receives notice pursuant to this section shall still have the unconditional right to intervene in any pending civil action within 30 days after the receipt of the notice. And you may think, why in the world would they do this again, right? Well, the reason that they did is because now, unlike the old 17 version, now they try to provide some clarity as to when the notice has to be provided to the carrier, and then the clock starts for the right to intervene. And here it is. This is, I like to joke when I do this, this is the eye exam portion of the statute. Just real quick, I had a question here. Can an 065 agreement be entered with respect to a property damage claim? Appellate court hasn't decided that. Under the original 1959 version, there were 065 agreements for property damage claims that the courts seem to condone, but we don't know under the new statute. The people that wrote this would say no, that the only time you could do an 065 is for personal injury, bodily injury, wrongful death cases. I kind of like, obviously from my perspective, that reading of it, but we don't have an appellate court that has said that just yet. So getting back to this notice thing, you have to get notice of the 065 agreement when you can do them to the insurance company. But now we have very detailed rules on when the notice has to be provided. And this is really a response to the Britt and Aguilar and Loveland cases. And it's sort of complicated, but the thinking here is the legislature wanted to make sure that whenever the notice is provided, that there will be a lawsuit on file within that 30-day window in order for the insurance company to intervene into the case. And so, for example, in the first one, if there is an action seeking a judgment against the tortfeasor, if it's pending at the time of the execution of the 065, that's when you have to give notice. If an action seeking a judgment against the tortfeasor is pending at the time but is therefore dismissed, then when it's refiled, you have to give the insurance company notice of the suit, and that's when the 30-day clock starts. Again, that's a response to the Aguilar case, right, where it was on file, dismissed, refiled, and it took away the ability to intervene. Now the statute says if you do that, okay, cool, but you still have to give notice of the refiling, and then the insurance company has 30 days to intervene after that. And then the final one there, this is a reaction to the Britt case. If there is no action on the judgment, seeking a judgment against a tortfeasor when the agreement is entered, then when there is a suit on file, that's when you have to provide notice, and the insurance company has 30 days after that to intervene into the case. So it's all, I mean, no one would come up with this on their own out of the gate, but these, this new portion of the statute is clearly a reaction to the Britt, Aguilar, Loveland, cases, in an effort to make sure that, hey, you can still do 065s, that's permissible, but you got to give notice and let the carrier effectively intervene. We're not going to allow procedural timing strategies effectively defeat the right to intervene. So that is a significant change in the new 065. Just looking, here's a couple questions. There's a question here, what about, under the original 1959 version, if a carrier didn't defend in good, or didn't settle a case in good faith, they could do an 065. Does that carry forward under the new statute? The legislature, hopefully the courts will agree that the answer to that is no. That the thinking was, that this is the only time you can do you can do an 065. If you refuse to withdraw a reservation, or if you decline coverage. That's simply not, refusing to settle a case, you can't do an 065. That's what the folks that wrote this believe, and hopefully they feel that the courts will follow that. There's another question here: does the statute apply to a policy issued outside of Missouri, but where the suit's in Missouri? Happy to discuss that with you offline. Don't have much case law on that. Arguably, this statute would apply to any case in Missouri, even if the policy is outside, but we can, we don't have firm case law on that piece of it. Just flipping through here. The next thing that the legislature tried to fix or clarify is, okay, once the insurance company intervenes into the case, what do they get to do? Because remember, the 17 version didn't say what they get to do. Here's what the new language says in the statute: the intervener, that's the liability carrier, shall have all rights afforded to defendants under the Missouri Rules of Civil Procedure, that would include the insureds, and reasonable and sufficient time to meaningfully assert its position, including but not limited to the right and time to conduct discovery, right and time to engage in motion practice, and the right to a trial by jury, and sufficient time to prepare for trial. So what do carriers get to do when they intervene? They get to meaningfully assert its position. And I'm sure the meaning of those 4 words right there will probably be actively litigated over the next few years. But this is the 17 version didn't say what the carrier got to do. The new version does. You get to meaningfully assert your position. We have a question here on the timing of it, and I'll John, I promise I'll get to you on that one. As far as the effective date of it. So just a few other little pieces in here. There were some extras that the legislature threw into the 065 statute. Now all terms of 065 agreements have to be in writing. Many times there may be 065 agreements, and maybe there are other terms, assignment of claims, how much of a bad faith case will the insured retain, or will they pay certain amounts to the plaintiff. Under the statute now, all those sorts of things are supposed to be in writing. The new 065 statute also has a provision that says agreements entered under the statute are now admissible in any action for bad faith. That was always a hotly litigated thing in bad faith cases. Plaintiffs and insureds would argue very hard that the jury should never hear that there's an 065 agreement. the insurance industry always wanted those agreements into evidence, obviously, right? Because the insured would argue things like, because the carrier didn't settle the case or didn't, provide coverage, now I have this huge excess judgment against me. And the carrier would always want the jury to know, no, yeah, there's a huge judgment, but the insured's never going to have to pay for it, right? And whether or not that comes into evidence was always a big issue. The new statute says, yes, it does come in. There's also a line here that says that the insurance companies exercising of any kind of rights under this statute is not considered to be bad faith. Okay, that was always, not always, but that was an argument that you would see sometimes, is that the insureds would argue, the policyholders would argue, if the carrier intervenes into the liability case, litigates liability and damages, and argues to juries positions that are inconsistent with the insured's position, that somehow would screw up the insured's case. Carrier, by you jumping in here, you're damaging my defense, if you want to call it, of the case. And so just intervening, just exercising these rights somehow was evidence of bad faith. And so the new statute has a couple lines in here that says, no, it's not. The carrier can exercise its rights, and doing so is not necessarily bad faith. We had a question here about, the effectiveness of it. This new version of the statute went into effect August 28 of 2021. And as I said earlier, we don't have cases just yet that I'm aware of, or anyone where the appellate court has told us, these agreements, which ones are subject to this version of the statute versus the 17 version. However, as I mentioned when talking about the 17 version, some of the key language in the 17 is the same as the 2021. So I think what will likely happen is what we heard before, and that is 065 agreements entered before that date, before August 28 of 2021, will be subject to the 2017 statute. Agreements entered after this date will be subject to the new statute. Now, I will say there's another piece of it too. The arbitration statute was obviously amended to say that those are not valid on insurance companies unless they consented to them. That is probably effective, as that prohibition probably went into effect August 28 of 2021 as well. And any arbitration conducted after that date is probably invalid, even if the 065 agreement was entered before August 28 of 2021. So that's maybe a little nuance there. So I think at the end of the day, when you're looking at these things, if you have an 065 agreement, when was it entered, right? That's the big thing. Is it before or after this date? Because if it's entered after this date, it's very likely subject to the new statute. And I can just tell you, anecdotally, that, Katie and I working on these cases, we saw a ton of these over the summer, in a ton of arbitrations or threats to arbitrate. Folks were, rightfully representing their clients, trying to, get maximum value of their cases before this date turned around at the end of the summer, and it's kind of quieted down a little bit on that front ever since. So I think that's a realization that a lot of people had, that's probably the timing on it. Just looking here to see if there's any more questions. I know we're at the 1 o'clock. Can 065 agreements be premised on coverages other than liability coverage? No, I don't think so. I think 065 agreements, these are liability cases, and they're just for bodily injury, wrongful death, or personal injury. Another question, does the filing of a DJ still trigger the right to enter into an 065 agreement, have a coverage denial or refusal to withdraw? I think it could. If the insurance company is defending under reservation and that reservation is accepted, and then they file a DJ, that's not a denial of coverage, I don't think. But if there's been a reservation of rights, it's rejected, and then the carrier, instead of withdrawing the ROR, files a DEC, that is a denial of coverage. Once you have that denial, plaintiff and insured can now do an 065 agreement. So whether or not filing a DJ allows 065s really depends on when did you file the DJ. Did you file it in response to a rejection of an ROR, yep, they can do a deal. If you filed it and there was no rejection of the ROR, you could probably, they probably cannot do an 065 agreement. Question here, can I give the citation for the arbitration statute? Let's see here, hopefully I still have that. Yeah, it's revised statute of Missouri 435.415. That's the citation on the arbitration piece. So I don't know if anyone else has any more questions. I'm happy to take any others. I know, Jennifer, I know we're at the 1 o'clock, but if folks have other questions that I can answer publicly, I'd be happy to do it. Otherwise, you know, if there were questions, I know a couple of them I punted because I didn't want to talk about it in a public forum. There's our phone number, there's my email. Feel free to email me, call me, and we'll chat offline.
Thank you so much, Mike. That was fantastic. I know you had a lot of questions there. I did try to send you one of them that you punted on, so I did email that to you.
Oh, awesome.
But yeah, thank you for offering. So anyone watching, you know, there's his email, and I know, Mike, you're super responsive, so we really appreciate you being here. And I know it's an interesting area of the law. I know you joke about it, but it really is so important. So thank you very much.
Absolutely, happy to do it.
Yeah, and so hopefully we can get back here maybe again next year. So we'll talk about that, because there's always, it's a fascinating area. It's always changing, and it slowly changes, right? So when we talk a year from now, we'll know what the effects maybe of the new law change are. I guess we'll see.
Yeah, absolutely. The last 4 years were super interesting, and we kind of figured it out. Now it's all changed again. So it's time to go back to school.
Right. All right. Well, thank you, everyone. I hope everyone stays safe and stays well. And this will conclude our webinar.
Great. Thanks, everyone.